Thinking about buying property with a friend, family member, or business partner? It might sound like a great idea until it isn't. Today I'm sharing the biggest mistakes I see people make when co-owning property and how you can avoid them to protect your investment and your relationships. Hi, I'm Stephanie Cruz, a real estate and estate planning attorney here in Florida. Every year I help people sort through complicated, stressful, and expensive problems that started with a good intention, but no clear legal plan. Owning real estate with someone else can be smart, but if you don't set it up the right way, it can be a nightmare. So let's talk about the common mistakes I see and how you can avoid them. Mistake number one, not defining how you own the property. In Florida, how you hold title changes everything. From what happens if an owner dies to whether your share can be sold without their consent. Here are the types of ownership in Florida. Tenants in common. It's usually the default if not specified. Each owner can sell or leave their share to someone else without your permission. There's no automatic transfer to the other owner when somebody dies. Joint tenant with rights of survivorship. When one owner dies, their share automatically transfers to the surviving owner, and no probate is required. Tenancy by the entirety. This is for married couples in Florida. It offers extra creditor protection and automatic survivorship. One of the biggest mistakes is not knowing how your title is structured or assuming it works the way that you want it to. Mistake number two, not having a written agreement. So many people skip on this. Even if you trust the person you're buying with, you need a co-ownership agreement that covers who pays the mortgage, taxes, and insurance. Who's responsible for repairs and maintenance? Can one owner force a sale? What happens if one person wants out? What happens if somebody dies? Without this, you could end up in court battling over who pays what or whether the property must be sold. For example, I've seen siblings inherit property together. One wants to keep it, one wants to sell. Without an agreement, the court often orders a sale. Mistake number three, not considering creditors when you co-own property in Florida. Your co-owner's creditors can potentially place a lien on the property. For example, if your business partner gets sued, their interest in the property could be at risk. So what's the solution? Understand the risks before co-owning. Consider crafting an LLC for investment property to shield personal liability. Talk to a real estate attorney about structuring ownership for protection. Mistake number four, not planning for death or disability. What happens if your co-owner dies or becomes incapacitated? Without planning, their share would go through probate. You can end up co-owning with their heirs or their spouses or their children. Selling or refinancing could also become complicated. So what's the solution? Use proper title like rights of survivorship if you want the property to pass automatically. Use estate planning tools like wills and trusts. Consider buy-sell agreements or life insurance to fund a buyout if needed. Mistake number five, not considering taxes when buying property with someone else can affect property taxes, especially with Florida's homestead exemption rules, capital gains taxes when you sell the property, and gift taxes if you transfer your share without proper planning. Always consult with an attorney and a tax professional when co-owning property to avoid unpleasant surprises. In conclusion, co-owning real estate may be a smart financial move, but only if you take the right legal steps from the start. Don't make the mistake of assuming the trust alone is enough. Put everything in writing, understand your ownership structure, and get professional guidance. If this video helped you see some of the risks of co-owning property, give it a thumbs up and leave a purple heart in the comments.